Your Chief Information Security Officer receives an email at 9:14 on a Tuesday morning. The sender is the National Data Protection Authority. The subject line contains one word and one number, Article 32. The body of the email informs your organisation that it faces an administrative fine. The figure at the bottom of the page reads, €10 million, or 2% of your worldwide annual turnover. Whichever is higher, that is not a hypothetical. That is Article 83 of the General Data Protection Regulation. This is Codex report. We read the regulation so you do not have to. Every claim in this episode traces directly to the official text of Regulation EU 2016-679, the European Union's General Data Protection Regulation, as published in the Official Journal of the European Union on the 4th of May 2016. Every article number, every quoted passage, every penalty figure is drawn from that text. Nothing is paraphrased from memory. Everything is on the record. Read the source. Know the rule. Today we are reading Article 32, the Security of Processing Obligation that has been enforced since the 25th of May 2018. This is the article that determines what your organisation must actually do, in technical and organisational terms, to keep personal data safe.
Here is what we will cover. The 4 paragraphs of Article 32, one by one. Who owes each obligation, controller or processor? The 4 enumerated security measures the regulation singles out by name. The risk-proportionate standard. Certification as compliance evidence, the personnel control requirement, the breach notification regime under Articles 33 and 34, which is what triggers when Article 32 fails, the penalty framework under Article 83, and a 10-step compliance checklist you can take directly to your security and legal teams. We will also examine how Article 32 connects to Article 25, data protection by design, and how the regulation explicitly treats compliance with both articles as a mitigating factor when fines are assessed.
Let us begin.
This program is educational content. It is not legal advice. For guidance specific to your organization, consult qualified data protection counsel. To understand what Article 32 requires, we need to understand the problem it was designed to solve, and we need to be precise about the vocabulary the regulation uses. Regulation 2016-679, formerly the Regulation of the European Parliament and of the Council on the Protection of Natural Persons with regard to the processing of personal data and on the free movement of such data, entered into application on the 25th of May 2018. It is the European Union's comprehensive horizontal data protection instrument. It does not regulate a single sector. It regulates the processing of personal data wherever and by whomever that processing occurs within its scope. Article 32 sits in Chapter 4 of the regulation, in Section 2 titled, and I will quote the heading exactly,
Security of Personal Data.
The problem Article 32 addresses is simple to state and difficult to satisfy. Every other right in the regulation, the right of access, the right to erasure, the right to rectification, the right to portability, presupposes that personal data exists in a form that can actually be controlled. The moment a database is dumped, encrypted by ransomware, or silently exfiltrated, every other data protection right collapses. Article 32 is the foundation underneath the rest of the regulation. Before we walk through the article itself, 4 definitions are essential. The regulation provides each of them in Article 4, the definitions section, and Article 32 cannot be read accurately without them. Article 4, paragraph 7 defines a controller. E.
Controller means the natural or legal person, public authority, agency, or other body which, alone or jointly with others, determines the purposes and means of the processing of personal data.
Article 4, paragraph 8 defines a processor.
Processor means a natural or legal person, public authority, agency, or other body which processes personal data on behalf of the controller.
In plain terms, the controller decides why personal data is processed and how. The processor carries out that processing on the controller's behalf. A bank is a controller of its customers' transaction data. The cloud provider hosting the bank's database is a processor. The marketing analytics vendor running campaigns for the bank is a processor. Article 32 places obligations on both. The language reads throughout, the controller and the processor. Article 4, paragraph 12 defines a personal data breach.
Personal data breach means a breach of security leading to the accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed.
Note the breadth of that definition. A breach is not only an external attack. Accidental destruction counts. Loss counts. Alteration counts. Unauthorized internal access counts. The 5 harm categories in this definition, destruction, loss, alteration, unauthorized disclosure, unauthorized access, map directly onto the risk assessment factors that Article 32, paragraph 2 will require us to consider. Article 4, paragraph 5 defines pseudonymization, which Article 32 names as one of its enumerated security measures.
Pseudonymization means the processing of personal data in such a manner that the personal data can no longer be attributed to a specific data subject without the use of additional information, provided that such additional information is kept separately and is subject to technical and organizational measures to ensure that the personal data are not attributed to an identified or identifiable natural person.
The key element is the word separately. Pseudonymization is not the same as anonymization. Pseudonymized data can be re-identified by combining it with the additional information held elsewhere. The regulation treats pseudonymized data as still personal data, still in scope of every right and obligation, but recognizes pseudonymization as a valuable security measure.
With those 4 definitions in hand, let us now turn to the article itself. Article 32, paragraph 1. This is the operative core of the regulation security regime. Let me read the lead-in first.
Taking into account the state of the art, the costs of implementation, and the nature, scope, context, and purposes of processing, as well as the risk of varying likelihood and severity for the rights and freedoms of natural persons, the controller and the processor shall implement appropriate technical and organizational measures to ensure a level of security appropriate to the risk, including inter alia as appropriate.
Then 4 measures, each enumerated. Let me read them in turn.
A. The pseudonymization and encryption of personal data. The ability to ensure the ongoing confidentiality, integrity, availability, and resilience of processing systems and services. Ability to restore the availability and access to personal data in a timely manner in the event of a physical or technical incident. D. A process for regularly testing, assessing, and evaluating the effectiveness of technical and organizational measures for ensuring the security of the processing.
Let us break this down into its operative elements. Each phrase here is doing legal work, and the structure rewards careful reading.
First, who bears this obligation? the controller and the processor, both jointly, not one or the other, both. If you operate a service that processes personal data on behalf of another organization, you are a processor and you are bound by Article 32 directly, regardless of what your contract with the controller says. Second, the lead-in is a balancing test, not a strict liability standard. 5 factors must be considered. The state of the art, which means current industry practice, not bleeding-edge experimental technique. The cost of implementation. The regulation acknowledges that cost matters, though cost alone does not excuse inadequate security. The nature, scope, context, and purposes of processing. The more sensitive the data and the larger the operation, the higher the bar. And the risk of varying likelihood and severity for the rights and freedoms of natural persons. The greater the potential harm, the more security is required. Third, the standard the controller and processor must meet is a level of security appropriate to the risk. Not absolute security, there is no such thing. Not best available security, the cost factor explicitly modulates that. Appropriate security, calibrated to the risk profile of the specific processing operation. This is a deliberate design choice. The regulation was drafted to survive technological change, so it sets a flexible standard rather than mandating specific controls that would become obsolete. Fourth, the 4 enumerated measures. The phrase including inter alia as appropriate is critical. These 4 are not the entire universe of security measures the regulation contemplates. They are examples that the regulation chose to single out by name. Other measures, access controls, network segmentation, intrusion detection, secure development practices are not named here, but remain part of the appropriate technical and organizational measures. The controller and processor must implement. Now consider each enumerated measure in turn. Pseudonymization and encryption. Pseudonymization, we have defined. Encryption is not separately defined in the regulation, but it is named here as an exemplar measure. Encryption at rest, encryption in transit, encryption of backups. These are the standard technical implementations. The regulation does not mandate encryption universally. It names it as an example of an appropriate measure. But there is one place where encryption acquires direct legal weight, and we will reach it shortly when we look at Article 34. Confidentiality, integrity, availability, and resilience. This is the classic security triad: confidentiality, integrity, availability, with resilience added. Each term is doing distinct work. Confidentiality means data is not disclosed to unauthorized parties. Integrity means data is not altered without authorization. Availability means authorized users can access data when they need to. Resilience means the system can withstand and recover from adverse events. The regulation requires ongoing assurance of all 4, not point in time, ongoing. The ability to restore availability and access in a timely manner after a physical or technical incident. This is a backup and disaster recovery requirement, expressed in functional terms. The regulation does not say maintain off-site backups or achieve a 4-hour recovery time objective. It says you must have the ability to restore availability and access in a timely manner. What is timely? It depends on the risk profile and the impact of unavailability on the rights of data subjects. A process for regularly testing, assessing, and evaluating the effectiveness of measures. This is the audit requirement. Implementing security controls is not enough. The regulation demands an ongoing process for verifying that those controls are actually working. Penetration testing, vulnerability assessments, security audits, incident drills. These are the practical implementations of paragraph 1, letter D.
For the security or compliance officer, the operational consequence of paragraph 1 is this. Document each of the 4 enumerated measures against your current security architecture. For each, record the specific controls you have implemented, the rationale for why those controls are appropriate to your risk profile, and the evidence that the controls are operating effectively. That document is your starting position if a supervisory authority comes asking. Quick note, if this breakdown is useful, hit subscribe and turn on notifications. Back to Article 32 in a moment.
Article 32, paragraph 2, is shorter than paragraph 1, but it does enormous work. It tells the controller and the processor exactly which risks they must be assessing when they decide what level of security is appropriate.
Here is the text.
In assessing the appropriate level of security, account shall be taken in particular of the risks that are presented by processing, in particular from accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed.
Let us parse this carefully.
Notice the 5 enumerated risk categories. They are identical to the 5 harm categories in the Article 4, paragraph 12, definition of personal data breach: accidental or unlawful destruction, loss, alteration, unauthorized disclosure, unauthorized access. The structural symmetry is intentional. The risks that the controller and processor must assess under paragraph 2 are the same risks that, if they materialize, will be classified as breaches under Article 4 and trigger the notification regime under Articles 33 and 34. Notice also, transmitted, stored, or otherwise processed. The risk assessment must cover the entire data lifecycle: data in transit, data at rest, data in use. Each phase has its own risk profile. Each phase requires its own appropriate technical and organizational measures. Notice in particular. This is a non-exhaustive list. The 5 enumerated risks are the core, but the obligation is to assess the risks presented by processing generally. If a particular processing operation presents a risk that does not fit neatly into one of the 5 categories, that risk must still be considered. A practical risk assessment methodology under paragraph 2 has 4 steps. Step 1. Enumerate processing operations. For each operation, identify what personal data is involved, where it lives, who has access to it, and how it flows through systems. Step 2. For each processing operation, walk through the 5 risk categories. What is the likelihood of accidental destruction? What is the likelihood of unlawful destruction, loss, alteration, unauthorized disclosure, unauthorized access? For each, what would the impact on data subjects be if it occurred? Step 3. For each identified risk, evaluate the existing controls. Are they appropriate to the likelihood and severity? If not, what additional measures are required? Step 4. Document the assessment, the controls implemented, and the residual risk. This documentation is your evidence of compliance. One important interaction. Article 32, paragraph 2. Risk assessment is related to, but distinct from, the data protection impact assessment under Article 35. A DPIA is required only for high-risk processing operations. The Article 32 risk assessment is required for all processing operations covered by the regulation. In practice, a DPIA will subsume the Article 32 paragraph 2 assessment for high-risk operations, but lower-risk operations still require a paragraph 2 assessment even where a DPIA is not triggered. One further interaction worth noting. Article 25, paragraph 1 requires data protection by design. The lead into that paragraph uses almost identical language to Article 32, paragraph 1.
Taking into account the state of the art, the cost of implementation, and the nature, scope, context, and purposes of processing, as well as the risks of varying likelihood and severity for rights and freedoms of natural persons posed by the processing, the controller shall, both at the time of the determination of the means for processing and at the time of the processing itself, implement appropriate technical and organizational measures.
Article 25 directs the controller to bake appropriate measures in at the design stage. Article 32 directs the controller and processor to maintain those measures throughout processing. They are two phases of the same obligation, and the regulation explicitly couples them in the penalty framework. But we will get to that in segment 10.
The compliance action items from paragraph 2 are these. Conduct a documented risk assessment that walks through the 5 enumerated risk categories for each processing operation. Map identified risks to specific technical and organizational controls. Schedule a review cadence. The assessment is not a one-time exercise, and ensure the assessment is available for production to the supervisory authority on request. If you're following along, take a second to subscribe. We publish a new regulation deep dive every week.
Article 32, paragraph 3 introduces a tool that compliance officers should understand precisely because it is widely misunderstood.
Here is the text.
Adherence to an approved code of conduct as referred to in Article 40 or an approved certification mechanism as referred to in Article 42 may be used as an element by which to demonstrate compliance with the requirements set out in paragraph 1 of this article.
3 things to notice. The verb may be used as an element. Not shall constitute compliance. Not shall be deemed compliant. May be used as one element, one piece of evidence, in demonstrating compliance. Second, what is referenced? Article 40, Codes of Conduct. The regulation's text on Article 40, paragraph 1 reads,
The member states, the supervisory authorities, the board and the commission shall encourage the drawing up of codes of conduct intended to contribute to the proper application of this regulation, taking account of the specific features of the various processing sectors and the specific needs of micro, small and medium-sized enterprises.
And Article 42, Certification Mechanisms. The regulation's text on Article 42, paragraph 1 reads,
The member states, the supervisory authorities, the board and the commission shall encourage, in particular at union level, the establishment of data protection certification mechanisms and of data protection seals and marks for the purpose of demonstrating compliance with this regulation of processing operations by controllers and processors.
These are the regulation's own internal mechanisms. A code of conduct or certification approved under Articles 40 or 42 is what paragraph 32 to the 3 is referring to, not arbitrary industry frameworks. not generic security certifications, specifically instruments approved through the regulation's own procedures. Third, and most important, certification is not a safe harbour. Article 40, paragraph 4 makes this explicit.
A certification pursuant to this article does not reduce the responsibility of the controller or the processor for compliance with this regulation and is without prejudice to the tasks and powers of the supervisory authorities, which are competent pursuant to Article 55 or 56.
Certification demonstrates compliance effort. It does not transfer responsibility. The supervisory authority retains full enforcement powers regardless of certification. This distinction matters in enforcement. A certified organization that suffers a breach cannot point to certification as a shield. It can point to certification as evidence that it took compliance seriously. Those are different legal positions. What practical role does this play for the compliance officer? 3 roles. 1. Certification is an organizing framework. A recognized certification scheme provides a structured way to map technical controls to regulatory requirements. Even where certification is not pursued, the schemes published by data protection authorities under Article 42 can be used as gap analysis templates. 2. Certification is evidence in enforcement. If your organization is investigated following a breach, a current certification provides documented evidence that you implemented and maintained appropriate measures. That evidence interacts with the Article 83, paragraph 2 assessment of fines, which we will reach in segment 10. 3. Certification is contractually useful. When your organization engages processors, an Article 28 contract requires the processor to take Article 32 measures. A processor that holds a recognized certification provides clearer evidence of those measures than one that does not.
But a word of caution. Many compliance officers conflate Article 32(3) with general security certifications that are not approved under Article 42. The regulation specifically references Article 42 approved mechanisms. General industry certifications are not nothing. They constitute evidence of state-of-the-art and reasonable practice, but they do not have the specific legal status that Article 32(3) confers on Article 42 approved mechanisms.
The compliance action items from paragraph 3 are these. First, identify which certification mechanisms are Article 42 approved in your jurisdictions. Second, evaluate whether pursuing such certification is proportionate to the scale and risk profile of your processing. Third, where certification is held by your organization or your processors, ensure the scope of certification covers the specific processing operations at issue. Fourth, treat certification as evidence, not as compliance itself.
Quick reminder, subscribe and ring the bell so the next episode lands in your feed automatically.
Article 32. Paragraph 4 addresses the human factor in security. After 3 paragraphs about technical and organizational measures, paragraph 4 turns to the people who actually touch personal data.
Here is the text.
The controller and processor shall take steps to ensure that any natural person acting under the authority of the controller or the processor who has access to personal data does not process them except on instructions from the controller, unless he or she is required to do so by union or member state law.
3 operative elements. First, the personnel scope is broad. Any natural person acting under the authority of the controller or the processor. This covers employees, it covers contractors, it covers temporary staff, it covers anyone operating under either the controller's or the processor's authority, who has access to personal data. Second, the constraint is sharp. Such persons must not process personal data except on instructions from the controller, not on their own initiative, not for their own purposes, not even on instructions from the processor's management if the controller has not authorized it. The chain of authority runs from the controller, through the processor, down to the individual person. Third, the only exception is legal compulsion, where the person is required to process by union or member state law. Statutory disclosure obligations, court orders, regulatory inspections. Outside such legal requirements, the controller's instructions are the boundary of authorized processing. What does this mean in practice? It means access controls. It means need-to-know provisioning. It means training on the scope of permitted processing. It means contractual obligations of confidentiality. It means disciplinary measures for unauthorized processing. The regulation does not specify the implementation, but the outcome it requires is clear. People who can touch personal data process it only on instructions, never on their own initiative. Paragraph 4 connects directly to Article 28, the regulation's processor article. Let us look at the connection. Article 28, paragraph 1 reads,
"Where processing is to be carried out on behalf of a controller, the controller shall use only processors providing sufficient guarantees to implement appropriate technical and organizational measures in such a manner that processing will meet the requirements of this regulation and ensure the protection of the rights of the data subject."
The controller cannot use any processor. The controller may only use processors that provide sufficient guarantees of appropriate measures, Article 32 measures in particular. Article 28, paragraph 3, then sets out what the contract between controller and processor must contain. Subparagraph C requires that the contract stipulate, in particular, that the processor
takes all measures required pursuant to Article 32.
Read those two provisions together. The controller must vet processors for sufficient guarantees of Article 32 measures. The contract must require the processor to take all Article 32 measures. The processor's personnel must process only on the controller's instructions. This is a chain. Each link is a separate legal obligation. Each link is enforceable. For the compliance officer, this means processor management is an Article 32 obligation, not a separate work stream. When your organization engages a new processor, the Article 28 contract is the instrument that imports your Article 32 obligations into the processor relationship. When your organization acts as a processor for others, you are subject to Article 32 directly, and your contracts with sub-processors must impose Article 32 obligations on them.
One enforcement implication that compliance officers should internalise. If a personal data breach occurs at a processor, the controller does not necessarily escape responsibility. Article 28, paragraph 1 placed an upstream obligation on the controller to vet the processor for sufficient Article 32 guarantees. If that vetting was inadequate, the controller has its own Article 32 exposure for the failure. The controller's defence depends on documented vetting and contractual provisions, not on pointing at the processor.
The compliance action items from paragraph 4 and Article 28 are these. First, implement and document role-based access controls for all systems processing personal data. Second, ensure that all personnel with access have signed confidentiality and data handling commitments. Third, for every processor relationship, maintain an Article 28 compliant contract that imports Article 32 obligations explicitly. Fourth, conduct documented due diligence on processors before engagement, focused on their Article 32 measures. Fifth, where you act as a processor, ensure your sub-processor contracts mirror these requirements. Article 32 governs the security measures the controller and processor must implement. Articles 33 and 34 govern what happens and the measures fail and a personal data breach occurs.
Article 33, paragraph 1.
In the case of a personal data breach, the controller shall, without undue delay, and, where feasible, not later than 72 hours after having become aware of it, notify the personal data breach to the supervisory authority competent in accordance with Article 55, unless the personal data breach is unlikely to result in a risk to the rights and freedoms of natural persons.
The 72-hour notification window is the most widely cited number in the entire regulation. Let us be precise about how it works. The clock starts when the controller becomes aware of the breach, not when the breach occurs. Awareness, in this context, means the point at which the controller has a reasonable degree of certainty that a security incident has resulted in personal data being affected. Initial detection of an anomaly is not necessarily awareness. Confirmation that a breach has occurred and that personal data is involved triggers the clock. The notification deadline is 72 hours where feasible. The regulation explicitly contemplates that notification may be delayed. Where notification to the supervisory authority is not made within 72 hours, it shall be accompanied by reasons for the delay. Those are the regulation's words. There is one exception to the notification obligation. Notification is not required where the breach is unlikely to result in a risk to the rights and freedoms of natural persons. That is a high threshold for organizations to meet. The default assumption should be notification. Non-notification requires documented analysis showing that the unlikely risk threshold is met. Article 33, paragraph 3 specifies what the notification must contain at minimum.
A. Describe the nature of the personal data breach, including, where possible, the categories and approximate number of data subjects concerned, and the categories and approximate number of personal data records concerned. B. Communicate the name and contact details of the data protection officer or other contact point where more information can be obtained. Describe the likely consequences of the personal data breach. D. Describe the measures taken or proposed to be taken by the controller to address the personal data breach, including, where appropriate, measures to mitigate its possible adverse effects.
4 content requirements: description of the breach, contact point, likely consequences, remedial measures. If any of these cannot be provided in the initial notification, the regulation permits phase notification under Article 33, paragraph 4. Article 33, paragraph 5 imposes a documentation obligation that exists independently of the notification obligation.
The controller shall document any personal data breaches, comprising the facts relating to the personal data breach, its effects, and the remedial action taken. That documentation shall enable the supervisory authority to verify compliance with this article.
All breaches must be documented, including breaches that fall under the unlikely to result in a risk exception. The documentation must enable the supervisory authority to verify compliance. This means the documentation must show the breach, the analysis that led to the conclusion that notification was not required, and the remedial action. Article 34 then addresses communication to the data subjects themselves, a separate and stricter obligation.
Article 34, paragraph 1.
When the personal data breach is likely to result in a high risk to the rights and freedoms of natural persons, the controller shall communicate the personal data breach to the data subject without undue delay.
Article 33 notification to the supervisory authority is triggered when a breach is more than unlikely to result in risk. Article 34 communication to data subjects is triggered when a breach is likely to result in high risk. The thresholds are different. The audiences are different. The timing, without undue delay, is also different from Article 33's 72-hour rule, and in practice will typically be slower, because data subject communication requires careful drafting. But Article 34 has an exception that connects directly back to Article 32. Article 34, paragraph 3, subparagraph A.
The controller has implemented appropriate technical and organizational protection measures, and those measures were applied to the personal data affected by the personal data breach, in particular, those that render the personal data unintelligible to any person who is not authorized to access it, such as encryption.
This is the encryption clause. If the personal data affected by a breach was encrypted, and the encryption renders the data unintelligible to unauthorized persons, the controller is excused from communicating the breach to data subjects. This is the practical legal weight of Article 32, paragraph 1, letter A's reference to encryption. Encryption is named as an example security measure in Article 32. Article 34, paragraph 3, then operationalizes that example as a concrete legal benefit. An organization that encrypts personal data not only complies with Article 32, it acquires a defense against the most painful breach notification obligation in the regulation.
For the compliance officer, the practical lesson is this. Article 32 and Article 34 must be designed together. The encryption measures you implement under Article 32 are the measures that will determine whether you have to communicate breaches to data subjects under Article 34. That decision matters enormously for reputational and operational reasons. Build the encryption architecture before the breach, not after. If you want more episodes like this on EU regulation, subscribe. It's the single thing that helps us most. We have now read every paragraph of Article 32 and the breach notification regime that triggers when Article 32 fails. The question a compliance officer must answer next is, what happens financially if we do not comply?
Article 83 of the regulation sets out the administrative fines framework. Let me be precise about which tier applies to Article 32.
Infringements of the following provisions shall, in accordance with paragraph 2, be subject to administrative fines up to 10,000 EUR, or in the case of an undertaking, up to 2% of the total worldwide annual turnover of the preceding financial year, whichever is higher. The obligations of the controller and the processor pursuant to Articles 8, 11, 25 to 39, and 42 and 43.
Article 32 falls within the range Articles 25 to 39. That places Article 32 violations in the Article 83 paragraph 4 tier. The fine ceiling is 10 million euros, or 2% of worldwide annual turnover, whichever is higher. For context, the regulation has a higher tier as well. Article 83, paragraph 5.
Infringements of the following provisions shall, in accordance with paragraph 2, be subject to administrative fines up to 20,000 EUR, or in the case of an undertaking, up to 4% of the total worldwide annual turnover of the preceding financial year, whichever is higher.
The higher tier applies to violations of the basic principles, lawful bases, data subject rights, and unlawful international transfers. Article 32 is not in the higher tier, it is in the lower tier. But lower is relative. For an undertaking with 2 billion euros in turnover, 2% is 40 million euros. The whichever is higher formulation means the percentage figure dominates for large enterprises. The factors that supervisory authorities must consider when imposing a fine are listed in Article 83, paragraph 2. The list is long and worth understanding. Let me read the most significant items.
A. The nature, gravity, and duration of the infringement, taking into account the nature, scope, or purpose of the processing concerned, as well as the number of data subjects affected and the level of damage suffered by them. Any action taken by the controller or processor to mitigate the damage suffered by data subjects. D. The degree of responsibility of the controller or processor, taking into account technical and organizational measures implemented by them pursuant to Articles 25 and 32.
Pause. On subparagraph D, the regulation explicitly directs supervisory authorities to consider, when assessing a fine, the technical and organizational measures the controller or processor has implemented under Articles 25 and 32. This is the regulation's own statement that Article 32 compliance functions as mitigation in fine assessment. An organization with documented Article 32 measures faces a different penalty calculation than one without.
F. The degree of cooperation with the supervisory authority in order to remedy the infringement and mitigate the possible adverse effects of the infringement. H. The manner in which the infringement became known to the supervisory authority, in particular whether, and if so, to what extent, the controller or processor notified the infringement.
Subparagraph H links directly to Article 33. Whether the controller notified the breach itself and the manner of that notification is a fine assessment factor. Self-reporting through Article 33 is not just a notification obligation, it is mitigation evidence under Article 83.
Cited adherence to approved codes of conduct pursuant to Article 40 or approved certification mechanisms pursuant to Article 42.
And subparagraph J confirms what we discussed in Segment 7. Adherence to Article 40 codes of conduct or Article 42 certification mechanisms is an explicit factor in fine assessment. Certification is not a safe harbour, but it is documented mitigation.
For the compliance officer, 3 practical points about this penalty framework.
First, the penalties are not automatic. Article 83 directs that fines must in each case be effective, proportionate, and dissuasive. The supervisory authority has discretion, but that discretion is guided by factors that reward proactive Article 32 compliance. Documented technical and organizational measures, cooperation, mitigation, self-reporting, certification. Second, Article 32 compliance is its own mitigation. Subparagraph D of Article 83 paragraph 2 makes this explicit. Documented, evidenced, current. Article 32 measures convert from a compliance overhead into a fine reduction position the moment something goes wrong. Third, the penalty framework has been in force since the 25th of May, 2018. This is not future law. Article 32 enforcement has been live for the entire period, the regulation has been in application. Article 32 does not exist in isolation. It interacts with other articles within the regulation and with regulatory frameworks beyond it. The most important interaction within the regulation is with Article 25, data protection by design and by default. We already saw the textual parallel between Article 25, paragraph 1 and Article 32, paragraph 1. Both use the same balancing language. Both impose technical and organizational measures obligations. Article 25 governs the design phase. Article 32 governs the operational phase. Article 83, paragraph 2, subparagraph D, couples them as joint considerations in fine assessment. In practical terms, this coupling means the compliance officer should not treat Article 25 and Article 32 as separate work streams. The technical controls implemented under Article 25 at design time are the controls that will be evaluated under Article 32 in operation. The two articles are the same architecture viewed at two different moments. The interaction with Article 28 we have already covered. The processor relationship is governed by a chain of obligations. The controller must use only processors providing sufficient guarantees. The contract must require Article 32 measures. The processor must implement them. The interaction with Articles 33 and 34 we have also covered. Breaches that occur despite Article 32 measures trigger notification obligations. Encryption under Article 32, paragraph 1, letter A directly affects the Article 34, paragraph 3. Communication exemption. Beyond the regulation itself, two cross-jurisdictional interactions deserve mention. First, the European Union's Artificial Intelligence Act, Regulation 2024-1689, contains transparency obligations under Article 50 that we covered in our previous episode. Article 50, paragraph 3 of the AI Act explicitly cross-references the General Data Protection Regulation for emotion recognition and biometric categorization systems. Any AI system that processes personal data is subject to Article 32 of the GDPR, in addition to its AI Act obligations. The two regulations operate in parallel, not in alternation. Second, the European Data Protection Board, the body composed of the heads of the national supervisory authorities, publishes guidelines that interpret the regulation's text. While guidelines are not themselves binding law, they shape supervisory authority practice. For Article 32, the relevant guidelines include guidance on personal data breach notification under Articles 33 and 34, which clarify the standards for assessing risk and the contents of notifications. The compliance officer should consult the current published guidelines for any specific question.
One further point about extraterritorial reach. The regulation applies under Article 3 to any controller or processor established in the European Union, regardless of where the processing occurs. It also applies to controllers and processors not established in the Union, where the processing relates to offering goods or services to data subjects in the Union or monitoring the behaviour of data subjects in the Union.
This means a United States company that offers a service to European customers is subject to Article 32 in respect of those customers' personal data. A Brazilian company that monitors European website visitors is subject to Article 32 in respect of that monitoring. The physical location of the controller or processor is not the determinative factor. the location of the data subjects, and the nature of the processing relationship is. For non-EU compliance officers, this has direct practical consequences. If your organization has any European customer base, any European employee data, any monitoring of European users, you are subject to Article 32. The standard is the same as it is for European established controllers.
One more reminder, subscribe before the checklist if you haven't already. Final stretch coming up. We have read Article 32 in the regulation's own words. Every paragraph, every enumerated measure, every interaction, every enforcement consequence. Let me now consolidate the compliance actions into a single checklist. 10 steps, derived directly from the regulation.
1. Document your Article 32 paragraph 2 risk assessment. Walk through the 5 enumerated risk categories: destruction, loss, alteration, unauthorized disclosure, unauthorized access for each processing operation. Map identified risks to specific technical and organizational controls. 2. Implement pseudonymization where technically feasible. The Article 4 paragraph 5 definition is your operational template. Keep the additional information separately and protect it with technical and organizational measures. 3. Deploy encryption at rest and in transit for personal data. Encryption is not universally mandated by Article 32, but it is named as an example measure under paragraph 1 letter A, and it converts into a direct legal benefit under Article 34 paragraph 3 letter A in the event of a breach. 4. Establish backup and disaster recovery procedures that satisfy Article 32 paragraph letter C. The standard is the ability to restore availability and access in a timely manner after a physical or technical incident. 5. Schedule regular security testing, assessment, and evaluation per Article 32 paragraph 1 letter D. Penetration testing, vulnerability assessments, security audits. The regulation requires a process, not a one-time exercise. 6. Audit every processor contract for Article 32 compliance obligations. Article 28, paragraph 3, letter C, requires that the processor takes all measures pursuant to Article 32. Confirm that language is present in every processor contract your organization holds. 7. Implement role-based access controls and personnel training. Article 32, paragraph 4 limits processing to instructions from the controller. Make that limitation operational through technical access controls and contractual confidentiality obligations. 8. Prepare breach notification procedures aligned with Articles 33 and 34. Pre-position the templates. Identify the contact points. Train the response team. The 72-hour clock under Article 33 begins on awareness, not on incident occurrence. Design your detection and triage process accordingly. 9. Consider certification under Article 42 or adherence to a code of conduct under Article 40, where proportionate to your processing scale and risk. Certification is not safe harbor, but is documented mitigation under Article 83, paragraph 2, letter J10. Review the Article 32 risk assessment annually. The state of the art evolves. Threat landscapes evolve. Processing operations evolve. The risk assessment must evolve with them.
This was Codex Report. Every episode you just watched was produced entirely by artificial intelligence. The script, the narration, the visuals. the fact-checking pipeline. We use the most capable AI models available today, but AI makes mistakes. And if you caught anything I got wrong, please leave a comment. Your feedback is how we train better episodes. Comments also help us reach the YouTube algorithm. That's how we earn the resources to keep producing free, deeply researched content like this. So if this saved you time, subscribe, turn on notifications, and leave a comment with what you'd like us to break down next. See you on the next Codex report.